So, very good evening to all of you. Thank you very much for being there and joining us this evening on this special lecture by Professor Archie William Parnell, who is joining us from the US. And before we add him, I would like to introduce a bit. My name is Anand Prakash Mishra, the Director of Law Admissions and an assistant professor and assistant dean in the law school, working for Jindal Global Law School for last 9 years. And this is a very special year for us, despite all the COVID thing which we are facing in the world. It started, 2020 started great for us as a law school and as a university. For the first time in the history of Indian legal education, 2 Indian law schools were ranked in the QS World University Rankings, and Jindal Global Law School was one of them. The other was National Law School of India, University Bangalore. And I, being a keen observer of law schools and higher education in our country and this region, for last 8 years, QS, which is a London-based organization and globally reputed university ranking company, they were doing it, the subject-wise ranking of law schools. And none of the Indian law school could find a place in last 8 years out of top 300 law schools. For the first year in 2020, Jindal Global Law School is ranked among 101 to 150 law schools. And National Law School of India University is ranked in 151 to 200 law schools in the world. It's a very special year, particularly for law aspirants to understand that our law schools are now competing internationally and becoming world class. And I'm very hopeful another 3 to 5 law schools will find their place in global rankings in the years to come. Now, a bit about today's speaker, Professor Archie William Parnell. Very rarely we receive such professors in our law schools with the kind of industry and practice experience, because in our higher education system, once you choose to become a professor or an academic, you are not allowed to practice law. And that is also one of the issues which legal education faces, because you have to basically surrender your bar certificate, your bar membership, if you choose to become a full-time teacher, a law professor. Unlike medical schools or medical profession, where all the medical professors are also practicing doctors in hospitals, the law professors are not people who can practice law. They are not allowed to do so by law. And that is a educational reform issue. But Professor Archie William Parnell has been a professor in the United States, where there is no such bar. And he started his career in the year 1974. And I mean, even before I was born, a JD graduate from University of Southern Carolina, and also an LLM from the Georgetown University Law Center, which is a very, very prestigious and one of the largest law faculty in the US, on par with the Harvard, Columbia, and other law schools. And he worked with some of the most prestigious organizations, including Goldman Sachs and the Exxon Corporation. He even taught at many American law schools. And he is one of our distinguished foreign professors. In our Jindal Global Law School, we have 330 faculty members today. We maintain a faculty-student ratio of 1:10, and we have some over 3,000 law students on campus. This year, January, we recruited some over 90 new faculty members, and now we are actually the largest law faculty in whole of Asia. Almost double the size of, or maybe 3-4 times the size of any law faculty in our country. And it's a remarkable achievement, I feel. And that is why this faculty lecture series was planned. And it was also to introduce our faculty members to the general world and their lectures in the chosen areas where they could talk to students and even the aspirants, those who want to join the law school for various programs. So without, further delay, I would like to invite Professor Archie very soon, and he will start his lecture on the comparative taxation teaching in our law schools and why it's relevant and important. So, it seems there is some technical issue coming up. We are trying to add him from the US. And please bear with me for a few minutes. So, it seems the connection is lost and we are trying to reconnect. I will seek your apology and also patience for a few minutes. I'm very sure we will get Professor Archie very soon. So I was actually talking about the law school and a bit. Yeah, so he's getting connected. I feel we will be getting in very soon in few minutes. So I was, I have been a witness to how a world-class law school could be built in a place like Sonipat in Haryana, and it has been an amazing journey. For last 9 years, I have seen it growing from a 10-member faculty and 100 students to becoming a 330-member full-time faculty and over 3,000 law students. And today, when we are talking, a lot of our students are actually, they have been members of the bar, not just in India, in almost the Supreme Court or all high courts, but even the bar in California, in New York, in Australia, in London, in Singapore, in UAE, around the world. And I believe to a large extent our vision of being a global law school, a law school which is truly international in both a student and faculty body, has been achieved after this 11 years of hard work. And frankly, 10 or 11 years are nothing in the life of a university. We have universities in India. I went to University of Delhi, and Delhi University will be celebrating its 100th anniversary in 2024. And we have universities like universities of Bombay, Calcutta, and Madras. Which have already celebrated 150 years of their establishment. So we are 11-year-old university, and I believe it has been a great journey. I can see.
So Professor Parnell has joined us. He's having some trouble with his web.
Okay. So.
Hello. He can hear you, sir.
Yes, hello. I'm sorry the video is not working on this end, but we'll just do this by audio if that's all right with everyone. I wore a tie today just for this video, and I could probably take it off now, but never mind. Next time we'll make sure that the video will be able to work.
Perfect, Professor, perfect. You please go ahead with your lecture, and I am also switching my webcam off. Please go ahead with the lecture. We have a lot of attendees waiting. Thank you. Thank you so much for being there.
Thank you. Thank you. I've been asked to talk about, the title of this presentation is The Relevance of Teaching Comparative Tax Systems in Law Schools. And to me, when you talk about the relevance of teaching a subject in a law school, that means why should we teach it? I mean, what's the point of teaching it? You know, and so for me, I submit that there are three very strong reasons why we should do this, especially comparative tax studies. And that's firstly because it's interesting and it's an engaging topic. Law students will have had some familiarity with the tax system where they live, but the contrast and the and the comparison triggered by a comparative course is interesting, and it engages students because they can sort of see how they do it where they are and how other countries do it, and so that contrast engages the student, and that's always important when you're trying to teach anything, to have that engagement. The second reason is that it's a topical. It's very topical, and the study of tax systems gives insights into why businesses and why countries act the way they do, and why they do certain things, or why certain transactions are undertaken in a particular manner. It is my view, having worked in the tax area for decades, that tax laws underlie and it can explain a lot of behaviors. And so you can get a lot of insights by studying tax systems, especially when you're contrasting and comparing tax systems. The third reason I submit that comparative tax systems should be studied in law schools is that there are a lot of problems, as we all know, with tax systems. There's nothing that happens almost every day that someone doesn't complain about some sort of tax. And when there are a lot of issues and a lot of problems with tax systems, and when you have tax relationships between countries, those problems can actually be exacerbated, and so there is a lot of low-hanging fruit, so to speak, for students to pick topics for research papers. And in this way, given the fact that they would be researching and talking about real problems, it allows students to help solve real problems. So firstly, they are engaged because it's a topical subject. It explains a lot of behaviors, and it allows them to help solve real problems. So the objective of, so what I want to do is now, with that as background as to why we should teach comparative tax systems, I'd like to give you an example of what we did at the Jindal Global Law School this term to those that are on the phone, because Professor Jha and myself co-taught a course that was entitled "A Tale of Two Tax Systems: Discerning Solutions for India and U.S. Tax Disputes." And so, next slide, please. So I firstly want to, on this particular slide, I have reference to Dr. Tharoor. He is a very esteemed gentleman, member of parliament in India. He's a friend of the university. And I have a link here to a YouTube where he gave a speech about India and millennials in India. It was one of the 10th anniversary lectures at the university, and in it he said to students, "You need to solve problems. It's up to you what the future is." I urge anyone that's interested to watch this video, because it's an inspiring video about the development of India, what it means to be an Indian. And I am not an Indian. I'm from South Carolina in the United States, where I'm sitting right now. But I got goosebumps when I was watching that YouTube. And I suggest to everyone listening that it's certainly worth your time to look at that. So the idea here, the idea of the course is how we can discern solutions for U.S.-India tax disputes. And there are a high number of double taxation disputes, and how can they be resolved, and how can the disputes be resolved with certainty. And next slide, please. This is just an overview. So the OECD, the Organization of Economic Cooperation and Development, puts out statistics annually that talk about the tax disputes between countries. And as you appreciate, because there's cross-border commerce in goods and services, there are many times when each country on each side of that cross-border transaction will claim the right to tax it. And so those instances where two countries or more than two countries try to tax the same income, that's what's shown in these statistics, in the sense that there is procedures in tax treaties that allow countries to resolve these double taxation disputes through a procedure known as the Competent Authority Mutual Assistance Procedure. And as you'll see in the slide that was just on, India and the United States are at the very top. Can we go to the prior slide, please? Thank you. I'll say next slide when it's time to go to next slide. Thank you. So if you can see on this slide, if you just look, this is just the first page of a number of pages that set forth the inventory of the competent authorities in each of these countries of the double taxation transfer pricing disputes that they have. And you can see that India and the United States are at the very, very top of this list. And so at the start of 2018, the United States nudged out, if you will, India in the number. It had 694 cases, and India had 659. And at the end of that year, it flipped so that India had 710 cases, and the United States had 670. And so the objective of this course was to give students background as to the tax systems in the United States and in India, and then try to talk about ways that these double taxation disputes between United States and India could be minimized, reduced, have some certainty around them. And what we could find could have application not only to India and the United States, but also to other jurisdictions as well. Next slide, please. So this slide is trying to cram the tax development of India and the United States into one page, and it is impossible. I mean, you have law courses that study particular elements of each of these two giant countries' tax systems. And what this tries to do is just encapsulate all of it into one page. But by doing it, you can sort of come up with some interesting observations. One is that the income tax in India and the income tax in the United States, when it was first introduced, was roughly almost the very same time. It was in 1860 in India under the British Raj. It was a system that provided procedural advantages to British persons, but not to those of Indian ethnicity. It was a very unfair in terms of disputing tax and that sort of thing. And so, but it started in 1860. In the United States in 1862, the very first income tax was in the United States Civil War between the North and the South. That income tax was just temporary. At the end of the Civil War, the North, the side that won the war, decided to stop the tax sunsetted, so it expired and went out of existence. But the United States later in that same century tried to enact a tax again. And in 1895, there was a Supreme Court case saying that an income tax was unconstitutional under the U.S. Constitution. And then that required an amendment to our Constitution. And in 1913, the 16th Amendment was added to our Constitution, which permits an income tax as a direct tax in the United States. And so we have gone from 1913 to now we are living in 2020, a bit more than 100 years, and we've gone from starting an income tax in the United States to what we have now, which is, you know, pages and pages and pages of tax laws and regulations, and it's extraordinarily complicated. But it starts with a seed. And in India, in 1916, progressive income taxation was introduced, and in 1922, the right to appeal was strengthened. And of course, after the 1947 independence of India, the first income tax in India was in 1961. And then that was the time where India was, and I shouldn't speak to this because I know so little about it, but you know, India itself was, and you are much better and much more knowledgeable about this. India from 1947 up through 1991 was pretty much tried to do things itself. It did engage outside the country, but it had a system that was a bit insular. Nonetheless, they did enter into a tax treaty with other countries, and tax treaties are designed to eliminate double taxation and avoid fiscal evasion. And so the first income taxation treaty was with the country of Greece. And then in 1989, India signed its income tax treaty with the United States. And it has now many double taxation treaties. And those treaties have this procedure whereby if there are double taxation of the same income, the two countries come together in competent authority in order to attempt to resolve those treaties. Then in 1991, there was liberalization and there was the reversal of the license Raj. And that's the license Raj was pretty much, from what I read, from 1947, and then in 1991 started changing. So lesser bureaucracy, fewer needs to get permits, and et cetera, et cetera. And so things started opening up. And shortly thereafter, India introduced transfer pricing rules. And what I mean by that is it's where related parties, related entities transact with each other with goods or services, and under the transfer pricing rules, the transaction should be at arm's length. It should be a transaction that would be conducted with a third party, because if you're talking about controlled entities, controlled entities can very easily manipulate pricing to put profits in a low tax country and expenses in a high tax country. And so countries enact transfer pricing rules to ensure that the related parties deal with one another as if they are unrelated. And then, of course, the other highlight, and again, this is such a summary, it's so high level that it's looking at this from the moon. It's beyond 30,000 feet. But in 2012, the Vodafone decision was followed by very controversial retrospective amendments of Indian tax law, and that gave quite a considerable pause and concern to the international business community of the Indian administration of its tax laws. And so there's a comparable thing over on the United States side. I won't get into that. It's not the point of this lecture. But in 2013 and 2016 and 2020, the OECD and the G20 and other groups, the United Nations, have been trying to work on base erosion and profit shifting in order to have in the past, the rules were pretty much developed on trying to eliminate double taxation, and taxpayers were quite good at eliminating not only double taxation, but eliminating taxation. And so these actions of the G20 and the OECD and the UN are designed to ensure that companies, actually there is some tax. I don't think people want double taxation or triple taxation, but at the same time, governments don't want transactions that result in no taxation. And so the efforts of the OECD and other groups are designed to attempt to have taxation of profits in locations where they are earned. And that leads us to the last point on this slide, which is that there is a very strong action trying to come up with a tax result for the digitalization of the economy. It used to be that one was subject to tax based on bricks and mortar, where you have a physical presence. And in the digital economy, it's much more difficult to determine where profits arise. And so this effort of the G20 is an attempt to come up with a multinationally agreed consensus of allowing the fair and proper taxation of digital transactions in order to allow the taxation of profits where they arise. And so in the digital space, that means that the world is moving in the tax area as to add another taxing right to countries which would not require physical presence in order for a business to be taxed, but rather a digital presence could with users in a country could be sufficient in order to impose tax. Next slide, please. And so the first point on this is how do double taxation cases arise? A very straightforward example is if you have an Indian service center, say in Bangalore, Chennai, or anywhere. Earlier slide, please. Thank you. No, that one, thank you. What that is that if India says that there is, and the service center charges a U.S. multinational for those services, it may be that the Indian tax authorities audit the Indian service center and say, more profit, you generated higher profit, you should have charged your related multinational party more for the services that you undertook here in India. And as a consequence, we, the Indian government, assess tax on the additional profits that we say were earned here under our transfer pricing rules. And then on the other side of that, the United States IRS, the Internal Revenue Service, says, well, hang on, the U.S. entity did not pay the amount that you say should have been charged. They only paid the amount that was charged, and the U.S. multinational paid U.S. tax on that basis. And so as a consequence of that, you can see how double taxation arises. The Indian government will tax increased profit on the service center. The U.S. government will not allow an additional deduction for the additional expense. And so there's double taxation of the same income. So the mutual assistance, the mutual agreement procedures that I talked about earlier, and I'll just quote here, this is the Article 27 of the U.S.-India Tax Treaty, and it says, the competent authority shall endeavor. It doesn't say require, it just says shall endeavor to resolve these cases, come to a satisfactory solution to resolve these cases by mutual agreement. And the competent authority offices of the United States, of India, of Germany, of Japan, of Argentina, all of these countries work very, very hard at trying to resolve these double taxation disputes. But with a language in their international treaty that says that they only shall endeavor to do that, that results from time to time, not every case, but from time to time, agreements to disagree, and double taxation is not resolved. Now, this problem has been discussed between countries around the world, and there is an example of an agreement that the United States has reached with Japan to say that if after 2 years the competent authorities cannot resolve a double taxation dispute, then the case can go to mandatory binding arbitration, so that so that it sort of leaves the hands of the competent authority of the United States and the competent authority of Japan, and it goes to arbitrators that come up with an answer. And then that answer is one that gives certainty and actually resolves double taxation. Next slide, please. Now, this approach of requiring mandatory binding arbitration is supported by the United States and by other countries. Japan is not the only country that the United States has these mandatory binding arbitration rules in their tax treaties, Canada and others as well. But India and other countries do not support mandatory binding arbitration. And that's for a number of reasons. Primarily has to do with concerns of India and China because China doesn't like mandatory binding arbitration either. They have concerns that giving up this adjudication to private arbitrators, or even regardless of how prestigious the arbitration panel might be, does interfere with sovereignty. And so that has sort of held up agreement of this idea on the part of India and other countries. Now, as a consequence of this, this then means that there is no certainty that any particular tax dispute can be resolved. And that is causing a roadblock for the G20, UN, and OECD efforts in reaching a consensus on the cross-border taxation of the digital economy. Because in order for there to be agreement of this, in order to give additional taxing rights to countries where there are users and no physical presence, there is concern that there would be even more double taxation cases and perhaps triple, quadruple taxation cases. And so we need a system that allows the resolution where different countries have claims on the same income, that those claims can be resolved with certainty as opposed to an agreement to disagree. Because if you agree to disagree, that means that multiple levels of tax are paid, and then that in itself becomes it inhibits international trade, and it inhibits the international economy and growth. And as I alluded to on the slide that had all the information going back to 1860 for India and 1862 for the United States, the effort of the G20 OECD is now a major reordering of the international tax system, and it's to revise the work that was done 100 years ago by the League of Nations, which required generally a physical presence. So next slide, please. Now, this G20 mandate of trying to solve this, because we now live in a digital world. I mean, just look at what's going on right now. I'm giving a lecture to people that are 74 people that are 75. Someone just joined that is being done digitally. I mean, it's and so I'm not physically in India to do this. And of course, this is going on around the world, and it's being accelerated, as we all know, by COVID-19. And I should have taken a moment at the very beginning of this talk to just have our thoughts and prayers go out to those folks that are suffering as a consequence of this pandemic. But this effort of the OECD and G20 is going on. It's been sort of, the pandemic has sort of caused it to pause a bit, but it's a major change that we're talking about, a once in 100-year type change. And I'm not going to get into the details of what the various things that they're talking about are, but suffice it to say, I'll just drop down to the bottom, that there are governments as well as businesses that are saying that obtaining binding resolution of tax disputes, because there will inevitably be tax disputes, but making sure that we can solve tax disputes which will come up in the cross-border exchange of goods and services, especially with digital goods and services cross-border, that resolving those with certainty is the quid pro quo to agreeing to a new non-physical taxing right. Next slide, please. So that was the background that we gave to the class throughout the lectures that Professor Jha and I had at Jindal Global Law School earlier this year. And there were discussions by the class as to how this, what some people might think is an unsolvable dilemma, might be solved. And so it's going to Dr. Tharoor's suggestion that the students solve issues, that it's up to the students to solve the issues because they are the future. And so this is talking with them about a real problem that the world is facing, because tax is as I say, the underpinning to behavior, but it's also the underpinning of government's functioning. And so there were a number of solutions that were suggested during the course, and I'll go through them quickly. One was that a world tax court be created, and along the lines of the World Trade Organization review panels when trade disputes are adjudicated. There was a suggestion that be considered. Now, it just strikes me, and I think Professor Jha as well, that a world tax, if there are problems of certain countries with giving up cases to adjudicators, because that is giving up sovereignty, then giving up the adjudication of a double taxation dispute to a world tax court might be a road too far from a sovereignty point of view. And so this is shown in red on the slide as not being realistic in the world with the international relations of the world as they are today. Another suggestion was to work toward more effective mutual assistance procedures. There have been manuals that have been published by the UN as well as the OECD that talk about more effective mutual assistance procedures, and that's the acronym is MEMAP. Sounds a little bit like Mini-Me in Austin Powers, but MEMAC, manual on effective mutual assistance procedures. And there's a link there if anybody would like to take a look at that. They set out very good ideas. They're best practices that the competent authorities should undertake. Those MEMAP manuals have been out for a while now. They're very aspirational. They're not binding, and we are where we are now, even with these manuals from the United Nations and the OECD. The other thought is that when the G20 and the OECD and the UN are trying to design these new digital taxation rights, they should have an eye toward dispute resolution in the design of the rule itself, so as to minimize the actual dispute. And so what I mean by that is, instead of having subjective sort of rules, you have more objective rules. So if you have formula that work off of agreed templates, agreed numbers that give an objective result, that should lead to fewer disputes. But knowing human beings, there will be disputes about that, but there will be fewer disputes. And so that's why this is in green, because it's a good idea, and we know that effort is underway now in Paris, in New York, in Washington, in Delhi, in Tokyo, on trying to design these rules so as to prevent future disputes. And so that is we think is a good idea. Now there's another idea, which is to use the mandatory binding arbitration sort of idea, that process, but instead of using third-party arbitrators, use other governments. And so other governments could get together and form a small group so that they could resolve tax disputes as they come up in a tax treaty context. And it's somewhat akin to a world tax court, but it wouldn't be that, because it would be something where membership of the peer review group would shift over time. It's something that might be able to work, this peer review by other governments in these tax disputes, because instead of giving up sovereignty to a third party, you'd be asking other countries which you deal with I'm talking now of the perspective of a country. You're just having an additional procedure involving other countries to resolve the dispute. And so this is in purple. So we think that could work not only for bilateral disputes, such as we've talked about between India and the United States, but it could also possibly work for multinational disputes, which you can imagine can arise out of the digitalization of the economy, where you've got users all over the world. So that's the peer review instead of mandatory binding arbitration. So we would call it mandatory binding peer resolution, something along those lines. Next slide, please. So, you know, what would peer review actually mean? And, you know, at the moment, as we speak, the Forum on Tax Administration, which is made up of tax administrators from a number of countries around the world, already have their forum, and I've put the link there, and they have published a number of items. One of them is, and backing up a second, in the world today, tax authorities quite readily exchange tax information between them on their taxpayers. It's a compliance tool that tax administrators use. And so if someone has a bank account in France, then that information on that bank account can be exchanged with tax authorities in the United States, for example, or Japan. And so that information exchange is already using peer reviews because the agreements to exchange information between countries have been subjected to certain parameters in the rules, and those rules need to be determined to be whether countries are abiding by their exchange of information obligations. And so their peer countries get together and determine whether or not each of the countries that are engaged in these exchange of information protocols are doing it in accordance with the protocol. And so peer reviews are already done. And so the question here is just how peer review groups for the double taxation dispute resolution could be chosen, how they would be, how certain members would be chosen, how their procedures would be worked out. And there's a lot of detail that needs to be done in this, but it's an idea that might help remove the roadblock that we talked about earlier. Next slide, please. And we think we had a lot of discussion in the class about the constitutional Indian constitutional concerns of tax resolution of tax disputes. One is that Article 136 of the Indian Constitution allows the Indian Supreme Court to grant special leave for appeal of any order or any decree in any matter made by any tribunal in India. And so you wonder, with that kind of rule, there was a ruling given in a Morgan Stanley case on a transfer pricing type issue by the ruling tribunal, and my colleague at Morgan Stanley thought that this issue had been resolved and it had been done with certainty, but an Article 136 special leave application was made and granted, and that then sort of gives people concern. Well, is anything ever final in India unless it gets to the Supreme Court? But here, with a binding peer resolution that would need to be added to tax treaties in order for it to be effectuated, if it's added to tax treaties as a procedure, Article 51 of the Constitutions of the Indian Constitution explicitly directs the Indian government to respect treaty obligations. And so we think that this result would not only possibly, the peer review would not only work in the Indian-US context, but it could also work with multinational jurisdictions as well. Next slide, please. So before I get to this photo, I should say that Professor Jha and I sent a letter to the competent authority of the United States and the competent authority of India, a joint letter, giving both of them the outcome of the findings of this course, so that they have in front of them this idea of peer review. And it's just an effort of the folks that are in this photo. And by the way, this is not a complete photo of all the people that attended class, but and Professor Jha's photo is not in this. I had this photo taken on a day when Professor Jha was on a seminar in Vienna, and he was away, and so I was teaching the class by myself, and I thought, well, hang on, I need to get a photograph for my wife and send it to her to show her that I'm actually teaching. And so some of the students kindly came to the front of class and took this photograph, and that's what that is. And I sent it to Sarah, my wife, and you can see all the students in the class, and it was a wonderful experience to do that. Next slide, please. So these are some of the research papers that the students undertook or in the course, and they're just listed there, what they are, their subject matters. And you can see that I'm quoting from Dr. Tharoor, tying this back to the very beginning of my talk, because he said in his talk, you have to find the way. You, the students, have to find the way. And so this is the attempt of our class and our students to do this. And it was a very, very good experience. And I think we look forward to doing it again because there will always be problems that can be resolved. And with that, I'll end my lecture because I've gone on way too long, and I'd be happy to answer if there's any questions. No questions?
There are questions, Professor. I will be sharing you 3 good questions which our students have asked. And the first question is from Mr. Sumant Sudarshan. And Sumant asked, I am a first-year student of 5-year law program at Jindal Global Law School. How do you think that a first-year law student should approach international tax laws if the student intends to practice in the area? The area is highly disputed with respect to DTAAs and transfer pricing, but also interesting considering how authorities at both countries consider these transactions. So how a first-year student who is interested in international tax laws and who wants to practice it in future should approach the subject?
Well, the course that I've just discussed required preliminary courses before students were allowed into the course. This particular course was only available for students that had undertaken earlier tax courses. And so it's primarily available to folks that are toward the end of their term at the law school. And so for first year students, you certainly wouldn't be able to take this course, but I do think that the curriculum that the Jindal Global Law School has for students has certain requirements, and they are there for a reason, because to approach this international tax topic, you need an underpinning in a number of subjects, ranging from contract law to a whole range of other subjects. And so I would just urge that the student, if you're interested in this, just to try to undertake your core curriculum courses and do the very, very best possible, so that you can have the necessary underpinning to then take this course, which is an elective course later in your career at JGLS.
So the second question is from a student, Achintya Sharma. And Achintya asks, you think the arbitration of tax disputes that are international in nature would lead to more cases where countries would opt for a special rates of taxes given the confidentiality of said proceedings? So I will repeat. The student has asked, do you think the arbitration of tax disputes that are international in nature would lead to more cases where countries would opt for a special rates of taxes given the confidentiality of said proceedings?
Well, I mean, these tax disputes between under the mandatory arbitration, pardon me, under the mutual assistance procedure that we have going on now in the tax treaty context between India and the United States, those cases are confidential. You cannot, only the taxpayer will know the result of the case. It's not publicized. And actually, that was one of the recommendations that someone in the class suggested, that, you know, how these cases are actually resolved creates a precedential value for other cases. And so if there was a way by which those cases could be, the confidential aspects could be redacted, and then the results somehow made public so that they could provide, you know, sort of guidance to other taxpayers and other tax authorities, might be helpful. But the point is that the confidentiality of these cases is already there. That's one thing. And then the mandatory binding arbitration that has been agreed between, for example, Japan and the United States, the outcome of those are also confidential. And again, the same comment was made in class, that it would be helpful that there could be some sort of place that you could research to see it. You wouldn't want to find out the confidential aspects of a transaction or some business proprietary matter, but so that if you could see the outcome of the double taxation dispute with the confidential information redacted. And so these cases are currently confidential.
Wonderful. Professor Archie, there are two more questions which have come up just now. So though our time is going to be up, but I think we can have another 5 minutes. Sachin Agrawal is asking, is there any standing body or authority between the two countries which looks into tax disputes?
Yes, it is the competent authority. In the United States, there is an office that has been established as part of the Internal Revenue Service. And likewise, there is a special office in the Indian government that deals with these cases as well. And so it's officials from those two offices that meet. And my understanding is that they try to meet face-to-face at least twice a year. And of course, with all this technology, perhaps they could be meeting face-to-face digitally more regularly. This office in the United States deals with its counterparts in all other countries. And likewise, the Indian office in this manner deals with its counterparts and other countries where the two countries have entered into double taxation treaties with other countries. And the reason that that's important and why I have to say that is because it is the double taxation treaty between India and the United States that not only talks about how dividend income is going to be treated, talks about permanent establishments in each country. It talks about many things, how athletes are going to be taxed when they visit countries. It also talks about this procedure to resolve double taxation disputes. And so under tax treaties, you have this procedure. And as a consequence of this treaty obligation that these countries have entered into, and there are 3,000 or so multilateral tax treaties with countries around the world. Countries with tax treaties have an obligation under these treaties to establish a special office to deal with these double taxation cases.
So perfect, sir. There is one last question, and before that, there is a request from one of the audience, Ms. Amrita Priyam. Amrita is just inquiring, can we get the links which you used in your presentation so that it is easy for us to go through? So I believe we can get the links emailed to all the audience.
That would be fine with me. I mean, I would very much suggest that that people do take a look at the video that was done by Dr. Tharoor. It was a very uplifting.
Absolutely. So I will be even taking out the links used in your presentation and getting an email sent to every person attending the session. The last question is from a student, an attendee, Purushottam Kumar. Purushottam asks, why double taxation arises? Is it not intruding into the sovereignty of each other? I mean, the sovereignty of the two countries? Why double taxation arises? It's a very fundamental question.
Okay, well, I'll just go back to the example that I gave. You know, there are a number of service centers in India that service related companies that are owned by common interest, but the Indian Service Center services related companies in Japan, in Germany, and in the United States. And it is something that the Indian government will audit the results of the Indian service company, and the US, German, and Japanese companies will be paying fees to the service center for their activities. And so the Indian government, when it audits the service company, may find that in its views, under the transfer pricing laws that India has, that the service center did not charge its related companies enough. And as a consequence, the Indian government will assess additional tax on the service center. Now, the issue with that is that the company that's in Japan, Germany, and the other country in Germany, and the other company in the United States will have paid tax to those countries on the basis of expenses of their payments. And so let's just go through a simple example, very, very simple. So assume only two parties, United States and India. Assume the service company provides services and charges 10 to the United States company. The Indian government comes in and says it actually should have been 15, and so taxes 5 additional profits. The US company only deducted from its US tax return 10. And now, you know, the only way that would not be double taxation would be if the United States would allow a deduction of 15. And the United States would say, well, hang on, the amount of payment that you made to the Indian company was in accord with our transfer pricing rules. And so you have then a double taxation issue over that 5 between the United States and India, because they're both claiming tax on that. One is that there was no expense from the Indian company. There was no expense taken by the US company. of the 5, and on the Indian side, there's 5.5 that's taxed by the Indian government. So that's how that's an example of double taxation, and that's very straightforward. There can be all kinds of iterations of that, of course.
Thank you so much, Professor. And a lot of our audience are also posting thank you messages in the message box. So Dr. Sunita, Mr. Sachin Agarwal, I am seeing a lot of thank you messages. So I look forward to having you again, and maybe on another topic and something relevant to India, and more and more people could attend. And even some of the audience are requesting for your email address. If so, basically on the faculty page of Jindal Global Law School, all the official email addresses of every professor is provided. And I will also share if there is a request from an individual, a student or faculty member or a lawyer. And we really look forward to have you again. And at that time, we will ensure there is a video also.
Yes, that would be good. I would like to actually participate in a video conference via video.
But it was a great session, Professor, and thank you very much for starting early morning for us in the US, and have a great day. And thank you each and every attendee. We'll continue doing these webinars, and please attend them, ask your question. All the very best, and good night, all of you. Stay safe.
Thank you, everyone.
Thank you, Professor.